Do you think, Michael, there was an understanding then of the term public service, or public servant, if you like, that's somewhat missing today from legal practice?
Well, I don't know, but I think there might be a different attitude to people in the profession. Now, Kevin Murray once said to me that he would pay to be a barrister, and that was my own view. I couldn't wait to get into my chambers of a Monday morning. I loved it so much. So for me, it was a labour of love. But I think, particularly in the solicitor's profession, it's become more and more commercialised as the years have gone by. I mean, it's become a business rather than a profession, and Chief Justice Spiegelman, Chief Justice Bathurst have said as much in recent speeches that they've made over the last few years. But I think people saw it as a profession. You couldn't make a lot of money out of it in those days. In fact, I think I can almost pinpoint the time when the fees took off in New South Wales. It was the takeover of Grace Brothers, or an attempted takeover of Grace Brothers, and the bar saw what was then called merchant bankers were charging, and they just came to the view, I think, that they just weren't charging enough, and the fees just tended to shoot up in all areas. I remember about that time, or a little later maybe, we were shocked on the Bar Council by seeing a barrister's fees, of which there was a complaint. I think it was $12,000 when you might have expected a few years before that it would have been $2,000 or something like that. But the bar itself started to use time charging as well as the solicitors, and I know I used it in terms of opinions. Firm of solicitors, when I was at Silk, used to send me up briefs as to whether they had any grounds for appeal. I wouldn't have appeared at the trial, and I'd read the transcript of the evidence and the exhibits, and I'd send off a bill, and then Fred Heron, who was the vice president of the Law Society, wrote an article about time charging, putting down every 6 minutes as 0.1 of an hour, and so on. And so I just started to do this, and I was shocked at how much time you actually spent reading transcripts, looking at the law and so on. And these opinions, which I was sending out for around $250 or something, I think that I increased it about $800 when I realised how much time I was putting into it. So I think the time charging has caused fees to increase. The other big change at the solicitors' level has been the number of solicitors attending conferences or handling matters. For most of my time at the bar, there was one solicitor who was in charge of the case, and that solicitor saw you at conference and instructed you in court. And then, particularly with the bigger firms, sometime probably in the late 70s or early 80s, you began to see 3 and 4 solicitors come to the there'd be a senior partner who had a managerial role, and there'd be a partner who was more or less running the case, and there'd be a couple of younger solicitors and so on. So 4 people at a conference, whereas a few years before there was just the one person there. And another thing I think that's increased costs is that or may not have increased costs, but or big change anyway, is that you don't see older solicitors, for the most part, conducting litigation. They've either retired into managerial roles in the firm, or they've given up the profession, moved into commerce or something of that nature. But I think you'd be hard pressed to find somebody like Sir Norman Cowper or Gabriel Reichenbach from Allens, who were there in their 70s and so on. Fred Miller. There's a whole string of very senior solicitors who were instructing counsel. It's rare these days to find an instructing solicitor over the age of 40 or